17/8/22, it was of course listed in between, but my junior sought adjournment. It may can be listed after tomorrow, my lord.
Next week. Next week.
May I please, Lordship, with the consent of the appellant, I beg to mention item number 20.
Item number 20.
My senior is out of station.
What is item number 20? National Educational Society.
Next one.
Employee State Insurance. Who is for the other side?
I'm for the respondent.
You're for the respondent.
I'm for the appellant.
You're for the appellant.
I have no objection.
No objection.
Matter may be adjourned today, Lordship.
Okay, then today, then adjourn today, then listed again when?
Next week?
Next week. Are you sure?
Yes, Lordship.
What is this WP, WA file? What is your name?
As they.
Yes.
They.
Do you have any idea about the case?
No, Lordship, it is,
You have the file in front of you, you don't know.
Lordship, the appeal has been filed against judgment and order dated 26/11/21, passed in WPC 5822 of 2016. Lordship.
26/11/21.
Yes, Lordship.
The writ petition was dismissed.
Petition was dismissed.
Petition was dismissed. Petition is filed by National Education Society. What was the relief claim in that petition? Any idea? Only, madam, only two pages judgment. You have not read.
Lordship, in the writ petition, Lordship, it was held.
What was the claim? What is the relief sought for in the writ petition?
And area amount was wrongly.
You are not contributing to your employees. You are only profit making, interested in profit making, not trying to share with the employees. Is it the case against you? No. That what is the case against you? Why did you file the case in the writ petition?
For the respondent in the writ petition.
Okay, respondent. Okay, you are the one who issued the notice. Yes.
Yes, and that notice was wrongly received. Wrongly delivered to us.
Wrongly delivered. And what should be rightly, how it is to be rightly delivered?
No. Actually, the petitioner is wrongly claim an area amount,
It is not an area.
not an area.
According to you, there was no area.
No area.
No, but then the learned counsel for the parties have been heard and they are in agreement that the issue involved in this matter is covered by a judgment of court bench dated so and so passing WPC number. What is the decision in that judgment?
Lordship, it was all Assam English Medium Schools Association and others. Was a
What
statement of,
was decided in that case?
it was decided that educational institution falls under the ESI Act,
Yes, I.
and
Therefore, they have to contribute.
yes, and the parties in respect to that petition, as the petition was stayed for a period, so they were exemption was in respect of that petitioners only, and they took the plea that as per this decision, educational institutions were exempted during that period, so they also should be exempted.
They are also seeking exemption.
Yes.
But
Yes.
in writ petition, Lordship, that single bench of this honorable court held that as they were not the party in that petition, so they will not be exempted.
Exempted.
And their school was closed
Okay.
in the year 2015 itself.
Oh, the school has been closed.
Yes. So they filed this appeal.
Why are you challenging on what ground you are challenging the notice
Because we also fall in that exception.
exception? So you are prepared and we'll hear you. Why you want adjournment?
After my senior is out.
Who
of
is your
station.
senior?
Taken and the
But you are doing well also. Your senior will not allow you to appear. Huh? Only is a standing counsel. You are a sitting counsel. Okay. What is it? Miss Dev.
S day.
Miss S. Dev.
Day.
D.Y.
T.Y.
Dev. Mentioning on behalf of Mr.
KK Nandi.
on the standing counsel for
ESIC.
praise for adjournment of the matter. Are also Mr.
MK Gogoi.
M.K. Gogoi for the petitioner. Then the matter will come up, according will come up next week.
Yeah. They,
Huh? When?
After 3 weeks, maybe.
After 3 weeks, why? We thought we'll allow your appeal.
Then 1
Then
week.
we'll- huh? Then 1 week. But nah, we thought if you next week, then we might, but 1 week, we don't know. Then we keep open everything. It may be allowed, it may be dismissed both. Okay. After a week, list after a week, ongoing.
obliged.
May it please your lordship. Lordship, I am praying for a unlisted matter listed on Friday, your lordship.
Why unlisted?
We filed last day, your lordship. Petitioner is under detention center
Oh, when did you file?
on 22/11, your lordship. Maybe on Friday,
22/11. Today is what day?
23 or
Next day. Will come up next week.
lordship on Friday.
Next
Petitioner
week come up. Next
I'll-
Monday, Monday. Yeah.
Monday.
May it please, my lordship. My lordship, we have filed in IA, my lordship, in
Oh, what?
criminal appeal. For
Criminal
IA
appeal.
for bail, my lordship.
You want bail?
Yes, my lordship.
How long you have been in jail?
My lordship conviction was last month only, my lordship.
Last month,
My lordship.
not even a month.
No. My lordship, the main appeal has been listed before your lordship on tomorrow list, my lord.
Tomorrow. It has
Yes.
been listed tomorrow.
My
He has
lordship,
been convicted 302.
my lordship.
What is the ground? He has not committed the crime.
No, we
Why?
are not guilty. Appellant are not guilty, my lord.
Why they are not guilty? There is evidence against
No
them.
prima facie materials are there, my lordship,
prima
against
facie.
appellant,
No prima facie material also.
my lordship.
Then how can a judge convict you?
My lordship, that's why we are before you,
It is
lordship.
bad. If there is no prima facie, they still judge convicted you. Okay, we'll hear tomorrow.
Oblige, my lordship.
I listed along with that.
Daily list for motion item number 1.
Yes. LCRS, they will fix for hearing, since the records have been received, the matter will be for hearing.
In the meantime, they
In the
may not,
meantime,
may not be deported, man.
may not be deported. Okay, we deported. Will be deported. But is there any other interim matter about arrest? What about arrest? You are only concerned with deportation.
It's a bail man. Bail matter considered after receiving of the case record. Petitioner's father's name appears in 1966 and 70 NRC.
So
And-
you don't want to be deported. But you may be arrested.
No, man.
Mr. Sharma is waiting
Bail.
to arrest you,
Bail.
to keep you in detention, but they will not deport you.
After receiving of the case records, your lordship says, allow me to grant the bail petitions after receipt of the.
Yeah, we have received the record.
Let the bail may kindly be granted.
They will be granted.
Yes.
Why?
Because otherwise, in the meantime, if the border police will arrest the.
But if
petitioner
you are
because
declared a
he
foreigner,
was-
then you
he
have
was
to be
declared to be
detained.
a foreigner.
But if you are declared a foreigner, you have to be detained. Why should you roam around? You should remain in detention if you are declared a foreigner. What is wrong with this order? What is wrong with this order?
But the petitioners are declared a foreigner 71, madam. Whereas the petitioner's father's name appears in 1966 and 71 NRC and 60 and 71 voter list. And only the foreigners tribunals made immediate conclusions that the petitioner did not linkage with his father's members. Whereas the petitioner submit the Gaura certificates and Ponsai certificates. But these two certificates clearly mentions the fathers of the petitioner's members. These documents are not denied by the government's members. And the NRC certificates and voter list 71 and 66. And so this is very old document. After marriage, the petitioner's name appears along with his father's in 1985. Husband. They may appear along with his husband. The protection may kindly give.
Mr. Sharma, the record says sin report of ERO.
Yes.
Her father and mother claimed to be elected in 1966 in Bukani, LAC, referred to tribunal for decision. Why? You should first find that he is suspected to be a foreigner. How can you just refer? You refer only when he is suspected to be a foreigner, no?
Lordship, link has to be established, Lordship. Link has to be established, Lordship.
Oh, that is a post of it. But when you start investigation, he said you must find that yes, this gentleman is a who is this? What name of this lady? Usharani Das. Usharani Das, you are a foreigner. Then Usharani Das will say, no, I am not a foreigner. I am an Indian. Okay, you are saying so. Then okay, tribunal will decide. But here you don't say that Usharani Das, you are a foreigner. She says you yourself record that her parents have names are recorded in 1960. So okay, you get bail. Okay.
Projected parents.
Okay, you get the bail.
Reference seems like
Are Mr.
Aise Sarkar.
SK Sarkar Lada Council for a petition. Records have been received. We have perused the record. On perusing the record, we are prima facie satisfied that the petitioner may be allowed to remain on bail in view of the observation made by the referring authority that her parents claimed to be electors in 1966 in Bokuni, LAC. The petitioner, according in the petitioner, may not be detained. Understand the impugn orders. If not detained, may not be detained. Sab same. Which district?
Golaghat.
Golaghat.
Item number 2.
Bakkar Ali.
Yes, madam.
We'll wait for the record. List this matter after commencing enabling to submit death certificate of the petitioner.
My lord.
Right.
Yes, so already received, my lord.
Okay.
My
Then
lord.
file it.
Yes.
File it.
But as per inquiry report, my lord, kindly see page 30.
No, you first file it.
Yes.
See what will happen? The
Yes.
police cannot detain you.
Yes.
The police cannot deport you
Yes.
because you are in a different.
Yes.
You are a place where the police cannot reach you.
Yes.
Sharma's police force cannot reach you. You have gone to a place. So you first file that certificate,
Yes.
file an implement application also.
Yes.
Okay.
And Lordship, this case may come together with the WPC 5184/2022.
What is that? Who has filed that?
Lordship, he claimed that this is a
Rejudicata.
No, my lord, he is already declared.
He is declared.
Petitioner already declared in
foreigner.
another case.
Another proceeding. Lord.
And he is a foreigner
Their
declared.
case is pending
Yes,
before this.
So you are a double foreigner.
A double foreigner.
Then you should go. But
double
he has already left.
A double foreigner, he has gone. My lord.
He has only left for some other location.
Yes,
Where we have no access.
Yes.
Okay. Okay, list this matter along with WPC number
5184.
5184. In the meantime,
20.
in the meantime, as it has been stated that the petitioner Bakar Ali alias Abu Bakar Mia has expired. His legal representatives may apply for implement if they wish to challenge the order of the tribunal declaring the said Abu Bakar Ali to be a foreigner.
God bless.
Item number 3.
Lord. This is a contested case. The father's name is listed, recorded in 66, 71, 77 voter list. And the linkage has been provided through Gaubura, my lord. And also the cousin has appeared as DW2.
Gambara also appeared.
Gaubura did not appear.
Why?
My lord, that is not been discussed even in this opinion, my lord. There is no
And the
whisper
cousin
about-
appeared.
Cousin appeared.
Cousin.
Yes, my lord.
Cousin means whose son?
Uncle's son,
Uncle.
my lord. At this stage, I am just pressing for interim bail, my lord.
Yes, Mr.
Yes,
Cousin
Lordship.
has appeared. He said.
After 5 years, Lordship, he come before this honorable court.
After 5 years, you
Yes,
come.
Lordship.
My lord,
And
my
there is
lord.
no specific reason.
My
And
lord,
for
I
5
have
years.
explained it. I have explained in
But then
para.
Mr. Sharma, 5 years also don't want to deport him.
Yes.
Maybe he's casted his vote also. Did you cast a vote in the last election?
No, no, my.
Oh, you didn't. Okay. See, 5 years you are allowed to roam around. So let him remain outside. Why you want to feed him after 5 years?
I think
Huh?
there is not necessary for granting bail, Lordship.
No necessary.
Already he was not arrested.
So you are not arrested.
Now,
In future also, he will not be
He will not
arrested.
be arrested.
no, my lord. Now the police is searching for the
Oh,
petition.
police is searching now. How do you say police is searching?
My lord, they are visiting the residence of the petition.
And then where at that time where do you stay? Where do you go?
She is in the relative's place, my lord.
Oh, Majira Nisa. Oh,
My lord.
lady. Oh. And don't arrest her, otherwise she's okay.
My-
Notice record interim.
Highly obliged.
Item number 4.
Yes.
Maybe
Yes.
your lordship, this represent again, against opinion dated 23.
How old is she?
51 years, your lordship.
51 years.
And she is in detention camp, your lordship.
Oh, detention camp.
Yes, your lordship.
And we have to see the order. We have to see the record. Huh?
See,
Or
her father's name has been enlisted in voter list of 1966.
who had
70.
appeared? Who had appeared?
Your lordship, her mother, your lordship.
Mother appeared.
Yes, your lordship.
Have
Her
you
mo-
annexed the evidence of the mother
yes, your
in
lordship.
the petition?
Yes,
Who
your
was
lordship. As OPW2, your lordship, in page number 45.
page number 45?
She's her stepmother, your lordship.
Ayesha,
Yes,
Elias,
sir.
Asha, 86-year-old. And what is the cross examination?
Your lordship, I have not annexed that.
What do you have not in 86-year-old woman coming saying that she's my daughter, Mr. Who 86-year-old will come to the tribunal unless she is the mother? Okay. No, the hard issue notice in 4 weeks. Call for the records. It has been submitted. The petitioner is in detention on the strength of the impugn order dated
Your lordship, 23/6/22.
22. So it has been submitted. The mother of the petitioner has appeared and gave testimony. A DW2, a PW2, OPW2. However, the same has not been appreciated by the. What is the opinion of the?
Your lordship, that she could not establish the linkage, your
Why is it?
Your lordship, because of some discrepancies in name, your lordship. Actually, the notice was issued to the petitioner by name, your lordship, Anwara Khatun, but her actual name is Aimur Khatun, your lordship.
Oh, what is the discussion by the learned FT
Your lordship,
about your mother's evidence?
Page number 54, your lordship.
54. What does it say here?
Para 16, your lordship.
OP, you know, the assessment, her father is showing failed to produce any list. She submitted some relevant document. Not a single voter list. Grandfather appear. OP could not establish linkage. What about the DW? DW2, OPW. What is that? What is the discussion about this evidence? Huh? No discussion.
No, your lordship.
Huh? Yes, Mr. Mother has come. We have not discussed her evidence.
Let the records come, lordship.
No, the judgment. See the judgment. There is no reference to the. She has given evidence. OPW2. There is no reference about that.
Lordship,
Huh?
below lordship.
What is that?
Below.
Yes.
Therefore, the OP could not establish her linkage with her grandfather and father as such. She
But
has
then what is
actually-
the evidence? She
Yes.
came and testified.
stated that
DW2. Okay, DW1 herself.
died
DW1 is the petitioner, your lordship.
Huh?
Her mother died 2 years back. That is in the year 2020. How can she come, lordship?
Alicia, I am a citizen. The proceeding in neither I am the real face of a citizen. This Ayasha, alias Asivan Beva. She testified, no?
19 or this. Even position.
Huh? 86-year-old. He come to page 45. Page 45. Or people cast a vote, marriage, village, get married to open two mothers, namely Asha and Mohan.
Yes.
Brother one's namely.
It was filed on 2019, lordship.
Huh?
November 2019, and
Correct,
he died
so
on 2020, lordship.
Correct, but then what is the evidence? Even if she
It was
dies,
no-
the evidence has to be
Not
discussed.
discussed, no.
Not discussed. From the record, the learned tribunal had not discussed the evidence of OPW2. Ayasha alias Asivan Beva is about 86-year-old, stated to be the mother of the petitioner. Under the circumstances, we inclined to grant bail to the petitioner during the pendency of this petition. And according to maybe release when 5,000. Yes.
Oblige, your lordship.
Item number 5.
Krishna Begum.
Next.
Yes.
In spite of having all sorts of relevant documents, the petitioner submitted before the planet member below. But he did not consider a single document. He only opined that these are doubtful documents.
Where is it? Let us see
My
that.
lord, kindly see his reason of decision.
Page,
Reason of decision, page 28.
page 20,
28, my lord.
28.
Reason of decision.
Reason and discussion.
Reason of decision. I have heard the arguments. Shall I read, my lord, or you?
Yes. Sir.
I have heard the argument of the learned council engaged for the OP and the learned registered government pleader for the state. On a careful perusal of the documents on hearing upon the learned council engaged for the OP as well as the learned AGP, it is found as follows. In support of the Indian citizens of our grandfather, the OP had exhibited only 2 documents, which are the photocopy of electronic NRC details and certified copy of the voter list of 1960 in the name of Abdul Khalik, whose age was in 32 years. If there's be so, he should have casted his vote.
Anybody who had
for
appeared,
in
who had
1916.
given any evidence, testimony, no. Where
The
appeared?
evidence given, my lord, I have given the evidence of my husband and my father, also other some relatives, brother, all the evidence I have given, I have adduced. But he did not, he only doubted, casted doubt. My lord. And all documents.
Husna Begum. Apart from Husna Begum, who had appeared in the tribunal, did anybody come in the tribunal and give deposition?
My lord, that her husband gave deposition.
What husband knows? He knows her only after marriage. Before the marriage, he did not.
And her father also came.
Father also.
Also came, and some some village relatives also came.
Where is it? Where is it? Where is it? How do you show that your father had come?
The documents I have not submitted.
Those
my lord.
examination.
But kindly
In
see,
this 20, who is OPW? OPW2,
OPW2 name is given, my lord, kindly see.
the
her.
headmaster.
My lord, kindly see her.
OP's father name is Jalaluddin. OPW2 had come. So you are in detention now?
No, my lord, I am outside, my lord. Kindly help me, my lord.
His
Kindly
case
help.
is also, order is first on 28/12/2018, Lordship.
Correct. That's the whole problem. This goes against you also. You are all, police are not, they are sleeping in your barracks.
My lord, my lord.
Police also sleeping in barracks. They are not doing anything.
In
Now somebody woke you
in-
up with danda. Now
With
they are-
danda,
in
with danda.
earlier occasion, Lordship, this honorable court has dismissed the petition, Lordship, for delay in filing the petition, Lordship.
Notice record interim.
Deputy.
Item number 6.
May I please, your lordship? There is contested case, lordship. Contested case, lordships. My mother appeared, lordships.
Mother,
Lordships.
show is the evidence.
58, lordship, page 58, annex of 15, lordships. But my mother is a damn, lordships.
Mother,
Page 58, lordship,
82-year-old.
82 years old, lordship.
And what does the tribunal say about your mother? Evidence? Was it discussed?
My mother is a damn, lordships.
My mother is a,
Damn, lordships. She cannot talk, lordships.
she cannot talk.
Lordship.
Oh,
But I
okay.
filed my evidence.
Okay, we'll examine. Notice record interim.
SP Dorang.
Item number 7.
Lordship. Lordship, it's a contested matter. Order is at page number 43, Lordship. Lordship, here I have adduces evidence of my uncle who have casted votes against with my father. Moreover,
Uncle.
yes, Lordship.
How do you say he's your uncle?
He had casted vote along with my father, Lordship.
Your father.
Moreover, DW3 is the younger brother, DW4 is the husband of the proceeding, and DW5 is my stepmother, who is also declared as an Indian.
Yeah, okay. Notice record interim.
Much of.
Item number 8.
Yes.
Against opinion 10/8/2022,
Yes.
Foreigners Tribunal, First Nogam.
Yes.
The petitioner is a widow actually, and she belongs to indigenous Assamese community. And she was born and brought up in Guwahati itself, in Potron Bazaar. And got married to a person who is also from the same community at Nagaon. And she now resides with, in her.
Yes, Mr.
Yes, ma'am.
Okay, notice record interim.
Much obliged.
Item number 9.
May it please your lordship, contested matter, 5 DWs have been examined, including the government Gambura and the school headmaster, lordship.
Okay, notice record interim.
Oblige your lordship.
Item number 10.
May it please your lordship. Lordship, my grandfather's name appeared in the voter list of 1965. My father's name also appeared in the voter list of 1970. My name started appearing in the voter list of 1993-97. My brother appeared before the tribunal. The government Gambura appeared before the tribunal and deposed before the tribunal, your lordship, as DW3, your lordship.
Yes, Mr.
Yes,
Notice record interim.
Item number 11.
May I please, Lordship, this is a contested matter, Lordship. Petitioner parents are voter of 66, 70, and 79, and mother also examined. But no discussion at all about. the
Mother was examined.
Yes, Lordship.
Okay, notice record interim.
Right.
Item number 12.
May I please the lordships? My lord, here I have challenged the reference on the ground of jurisdiction. I hail from the state of West Bengal. Even the inquiry, during the time of inquiry, I have submitted my voter ID card and the permanent residential certificate issued by the Panchayat from West Bengal.
Why did you come to Assam?
I'm a carpenter, and even in the reference also is mentioned. So for the sake of my livelihood, I was here, Lordship.
You don't, there is no work in Bengal.
So because most of the carpenters here are from West Bengal, Lordship. They are very good.
Is it so,
carpenters.
Mr. Sharma? Most of the carpenters are from Bengal.
Yes, Lordship.
Huh? Can we take judicial note of this fact? Huh?
Because the carpenters which I have come along, most of them are from West Bengal.
Yes, Lordship, notice may go.
Notice record interim.
Interim, Lordship, I just stay of the matter. Because stay of the proceeding, because I have, on the jurisdiction point, I have challenged.
Oh, you know, this.
It's not a contested matter, Lordship.
No, not yet over.
Not yet over.
Oh, it is continuing.
Yes,
Okay.
today is the date fixed even before.
Okay, call for the records.
Yes, Lord.
Yes, and stay of the proceeding.
Yes. In the
Deeply
meantime,
obliged,
in the meantime, the proceeding may remain state.
Deeply obliged.
If record is called for Lordship, then it is stay order. is-
Yes, stay of
But they
the,
may also come one day an application that a tribunal proceeding on the photocopies. Because I know stay order.
deeply obliged, Lordship.
Item number 13.
Please, your Lordship. Lordship, I was declared foreigner by dated 14/10/2022, Lordship.
But then.
By Zorat
it is
FT
not-
tribunal.
Not an issue. Item number 14, oh, Tazim. No, 13 or 14,
13.
13. Sozim,
Yes, Lord.
okay. Yes,
Lordship, I was declared foreigner by dated 14/10/2022 by Zorat FT tribunal, Lordship. Earlier, Lordship, one expertise order was passed, Lordship, and accordingly vacated, and we appeared there for fresh trial. Thereafter, Lordship, again, this order was passed, Lordship, by declaring me as foreigner, Lordship, post 1971 still, Lordship.
so,
And Lordship, here in this case, Lordship will say on page 35, Lordship,
yes,
page 35. That is, one order was passed, Lordship, on 29/4/2021.
oh, what is wrong with the judgment? You tell us, what is wrong with the opinion? What is wrong with that? You are declared a foreigner, so you are a foreigner. What is wrong with that?
Lordship, in that order, Lordship, the whole order was passed, Lordship, on observation that I was unable to speak on my great grandfather, not my father, not my grandfather, great grandfather.
Where is
Whereas,
this?
Lordship, my father's name was recorded in the NRC 1951, 1966, 1970,
So where is it? Where have you mentioned?
Lordship.
Let us see where the opinion of the tribunal. Opinion of tribunal, what is it?
Lordship, in page number 56, that is the judgment and order in page number 56. If we see the second para, Lordship,
Yes,
second para, even this all total 12 pages order, Lordship. In that 56 page number, that second para, here is, Lordship, the she has disclosed the name of the great of her grandfather-in-laws as Nasser Mondal, who had resided in all along and died at village Facetary itself, and he had never come to the Suparivita village. Lordship, this Facetary village and Suparivita village, this is the both villages are under same circle office, Lordship. So when we appeared there, Lordship, I disclosed all these things before the tribunal, Lordship. And Lordship, one interesting thing, Lordship, I want to draw attention to the Honorable Court, Lordship. Lordship will see page number 35.
yes.
Where, Lordship, on order dated 29/4/2021. Lordship will see that 29/4/2021. Where, Lordship, it was written that the judgment is not ready. Put up this case as and when judgment is ready for delivery. Very next day, Lordship, the judgment, actually the whole process was completed, so our engaged counsel appeared there instead of that petitioner, Lordship. But on 29/4, Learned Tribunal informed that judgment is not ready. Where 22/6, very next day, Lordship, the judgment is ready for delivery upon the procedure. Judgment is not, that means judgment is ready. Lordship, in between what happened, Lordship, we appeared on 5/7/2020, that is page number 37. We appeared with a petition, Lordship, where we requested that because it's already late, so we requested Honorable Tribunal that
the order may be passed by following the mandates of CPC Lordship. So on that day, Lordship 5/7/2022, the Honorable Tribunal passed one order where they mentioned Lordship that division by judgment of 2016, Justice B.K. Sharma and Manojit Bhai of the Honorable High Court, whereby personal presence of the proceeding was compulsory of the time of passing late compulsion of the time of passing final order.
Yes.
Lordship and issued warrant of arrest on that day, 5/7/2022. And we challenged that WA warrant of arrest order, Lordship, before this Honorable Court. And Honorable Court was pleased to set aside that warrant of arrest order, white dated, Lordship, this one, Lordship, WBC 5071 of 2022, dated 6/8/2022. Thereafter, Lordship, we again went there for my final order. But Lordship, on that day, what happened, Lordship, I was sent to judicial custody, Lordship, by giving that order, Lordship. And in that order, Lordship, if we go through the order passed by the learned tribunal, Lordship, it is in maximum para, Lordship, it is based on, like, I was unable to speak, my DWs are unable to speak about great grandfather.
Notice may go, Lordship.
Great grandfather, my great grandfather name was Nosar Mondal. My grandfather name was
Okay,
Boyakali
we'll issue
Mondal,
notice, we'll requisition the record, notice record.
Lordship.
The interim, you are in detention, na?
Yeah, I'm in detention, Lordship.
Okay, that will be considered on the receipt of the LCR.
Lordship, I may be allowed to.
We'll see the record, what you are saying, if it is correct, we'll release on the yes next.
Item number 14 for admission.
Lordship, I have one more submission. Lordship, in this case, Lordship, in this regard, Lordship, when case was declared on 14/10/2022, immediately we filed copy petition for order. But more than 1 month, tribunal didn't provide us order. When order was provided, then Lordship, we appealed. So, Your Honor, here in this petition, Your Honor, we filed like written statement, evidence, and they denied, Lordship. We will not
Give a
provide.
date after 2 weeks, fix this matter, returnable on pension. Give a date.
So till then, interim protection will be allowed.
12/12.
12/12. On 12/12 will consider.
Highly blessed.
For admission, item 14.
Reports have received, will.
Malad, here the fact hearing is that Malad, they do dual proceeding, Malad. The petitioner has been earlier, Malad, declared as a Malad in Indian citizen, not foreigner. They are after, Malad, in respect to the same proceeding, Malad, by the same tribunal had issued notice, Malad. So Malad, that is basing upon the Abdul Quddus case, Malad, the principle of res judicata has been Malad is applied. Malad, here in the similar order is there, Your Lordship. Basing on that,
In which you have been declared a foreigner?
my Lordship will find a page.
No, in which, before which tribunal? The
My
same
Lord,
tribunal.
Noga, my Lord.
The records have been there, FT case number?
My Lord, that is on FT case H number 175/2013. Your Lordship will find the order on page 25.
In 175, you have been declared a Indian.
Indian, my Lord. The relevant para is on page 28, my Lord.
And this is containing. And in this case, have you filed any?
Yes, my Lord. Contested case, my Lord. That's why I have been declared as in my Lord Indian citizen. Mine parents' name is appeared in the voter list of 1966. They are in 70.
In case counsel suffering from illness, no, but then in this.
was not taken before the tribunal, Lord. In the second case, Lord.
In the second case, you have not filed any, have you filed any evidence? Or order of arrest?
No, my Lord, in the second case, my Lord, that is in respect to the same proceeding, my Lord. The earlier I have
Correct.
been
In the second proceeding,
my Lord.
have you filed a written statement saying that it is hit by res judicata? No.
Not no, my Lord. I have approached to before this honorable court and
Directly.
my Lord.
Go there. You tell them I am the same person. Don't proceed. Like Abdul
Lordship,
Quddus.
I have given an observation.
Yes, certainly.
That I have given some order, my Lord, similarly passed in the same my Lord, identical case, my Lord.
And Mr.
B.K. Das, my Lord.
Learned Counsel for the Penal, also Learned Counsel for the state. In the present petition file challenging the proceeding initiated by the FT by the challenging the proceeding initiated by the which tribunal?
My lord, it is member foreigner tribunal 10 Nagaon.
10 Nagaon. In case number, page number?
FT case, FTD case number 1144.
1144 2015. It has been submitted, is a case with specific plea of the petitioner that since the petitioner was earlier declared to be an Indian in an earlier proceeding by the Foreigners Tribunal Hojai in case number FT/H/175/2013, white judgment order dated 11/11/2014, the present proceeding will not lie as being hit by the principal res judicata as held by the Honorable Supreme Court Abdul Qudus versus Union of India 2017, 19.
2019.
2019, ST, page number, you can just say the page number. Huh?
Case number
04,
2096.
304. However, and accordingly, we have submitted that as the second proceeding initiated against me will not lie. In this regard, it appears the petitioner has not informed the tribunal also, and it will be accordingly let the petitioner file a written statement stating that the petitioner had been already declared to be an Indian in the earlier proceeding in so and so, and that a present petition will not lie. And learned tribunal, after hearing the petitioner, will considering the maternal record, will pass appropriate order for stop as regards as to whether the present subsequent proceeding is hit by residue or not. If it is found on the basis of the evidence which may be documents and evidence that may be produced by the relied on by the petitioner, that the petitioner is the same person who was earlier declared to be Indian, the tribunal will conclude the proceeding in his favor and will not proceed further. With the above observation, present petition stands disposed of. The petitioner will appear for the FT and file necessary application and documents in support of his claim that the petition is by resumed within the period of 1 month from today. Let the LCR be remitted to the concerned foreigners tribunal forthwith. Next.
Item number 15.
This case, my lord, declared as foreigner, my lord, on 1971 scheme, my lord.
Since the records have been received, the letter will be listed for here.
In this case, my lord, there's no interrogation at all, my lord. Obliged, my lord. This is for hearing, my lord.
Okay.
Item number 16.
Obliged.
Lordship, in this case of the Lordship, on last occasion, notice was issued an interim order was granted, my lord.
Granted, very well.
My lord.
So you are happy.
No,
We'll
Lordship.
hear you. Since the records have been received,
My lord, record.
let the matter be listed for hearing.
Item number 17.
17 also similar, my lord. This is second round.
Same.
My lord, we have been this, I may be allowed to correct one.
Correct what?
There is a correction, I may be allowed.
What correction?
My lord, in interim order, Lordship, page number 10 was annexed prior to 9, man.
You mean, Mr. What is your name?
Jail customer.
Jail Asker Sam is that there's some minor error in the pagination
My lord.
in the petition, which he may be allowed to correct. That is allowed.
Obliged.
Next,
Item number 18.
Indian oil.
My lord, Indian Oil
You are
Corporation.
for Indian oil.
My lord.
What do you want? Why you filed this case?
My
With
lord,
appeal.
the corporation is agreed by the order of the honorable single judge.
What was the learned single judge
It's
directed?
regarding, my lord, the apprentice training,
Uh,
the selection for apprentice training, my lord, the petitioner was, my lord, selected, and she was my lord, inducted into the training, and thereafter it was found that she doesn't fulfill the eligibility criteria. And the wrong declaration was also given by the petitioner in her application. However, the honorable single judge said that since you have that may be a mistake, but since you have done it, so let her do it. Now, what happens, my lord, without going into the merits of the case, there is no stay order in this appeal, my lord, and the writ petitioner filed a contempt petition. That has also been withdrawn on the ground that she is no longer interested. It was a matter of training for an apprentice for a period of 12 months. Now, if she is not interested, perhaps, my lord, if that is-
apprenticeship for 12 months, she has completed 12 months. What more you want?
she has not completed, ma'am.
She has not completed.
Before that it was.
And she has left also.
Yes.
She has left. And we'll close it.
Okay.
Okay. Okay, and Mr. Lana, Senior Counsel for the appellant. Also, Mr. What is your name? You Saikia. You Saikia. The present appeal has been preferred against what is that order?
The judgment is at matter page 26.
Page 26.
Page 45, my lord.
Page 40?
Page 45.
Order dated 26/6/2019, refusing to entertain the allowing the petition,
My lord.
interfering with the termination of the present appellant. So that the petitioner by the IOC, thus allowing her to complete the apprenticeship training in terms of selection letter dated 30/4/2018. It has been submitted that said period of apprenticeship is only for 12 months, and that period has lapsed. Full stop. The petitioner also, the respondent, petitioner, also has shown no interest to pursue the matter in as much as that apprenticeship period is already completed. Mr. Saikia also submits that the petitioner respondent herein is also not keen to pursue the matter as it has been virtually infructuous. Under circumstances, the present appeal is closed as infructuous.
Obliged.
Item number 19.
In this case, I placed some accommodation lawsuit after filing.
Assam State Agriculture Marketing Board, what do you want?
Kindly,
Why you have filed this appeal?
we have filed this appeal against the judgment order dated 33.
Who is for the respondent?
Respondent is the ESOP food product lawsuit.
Who is he? Where is he? Who is the counsel?
Lawsuit, it was not admitted yet, lordship. Kindly absorb this matter for the day. Some subsequent development is there, lordship, after filing of this appeal, lordship. So, lordship, I want to obtain instruction from the appeal.
Appeal is against which order? Let us see.
Order is, lordship, at page 39.
Ishwar Wood Products. What was the order passed? Market committee, this committee. What was the effective order? Contempt.
That is page 46.
What was the direction?
Lordship, what the direction was to the
Requirement of passing reason order, either
What's it?
rejecting, accepting claim the respected claim being made for the purpose required to make a fresh claim for the chief executive. What is wrong with this? Why you are filing
This
this?
order has been passed during the pendency of the one SLP, lordship.
And in the what SLP, what had happened?
SLP number, now Lord, SLP was disposed of, lordship.
This was saying what?
That was in our favor, lordship.
In your favor.
Lordship.
So here also that, see, in this case, see, why did the learned single judge interfere?
What happened earlier?
As the Supreme Court had clearly provided in the order dated that the respondent Assam would be at liberty to collect the cess in
Yes, Lord.
accordance with the judgment in so and so and already stated so and so. It has been accepted, legal fiction had been created by section. In respect of claims, the plaintiff would be at liberty to produce his document which will indicate sale. But there is nothing, this order does not create any prejudice to you. We don't understand. See, if you read paragraph 15, in respect of the claims, annexure 1, the petitioner of liberty to produce a document so and so which may indicate a sale purchase corresponding to so and so purchase. If the petitioner is able to produce admission, the shall pass reason order. So how you are agree? We don't understand.
Also, what happened? There are two SLPs pending. One was challenged by that order of the division bench, challenged by the respondent, lordship, and also they file in contempt against the appellant board, lordship. After in the contempt proceeding, SLP permitted us to collect cess.
No problem. Even if you collect, if the petitioner is able to produce admissible material, shall pass a reason order. So here, nothing to do with that SLP.
Whatever, as per the act, there is alternate remedies there. So this is the order of the SLP, lordship.
Doesn't matter. See what the court, what the learned single judge, if the petitioner are able to produce admissible, they shall pass a reason order therein. You pass a reason order. On the other hand, if they fail to provide such document, the legal so and so another shall prevail. And para 94 of judgment dated,
Judgment
the SNP is against which judgment?
against the date 12/9/8,000.
12-9.
That's it.
So in that 12-9, what was the direction issued?
12 months, that is husband that, they challenge that the section 20 is the virus of the egg lordship. But that was. Lordship.
Oh, concerned with that. See, therefore, if that means they are liable to pay cess.
Lordship.
So you, then they will, so you ask for it. Now see that prevail, see, judgment and writ shall prevail and the concerned trader would be liable to be levied. So only direction is there. So how, in what way you are?
But they have challenged that order. Lordship.
Only thing in direction is that this, see, the petitioners are directed to produce admissible, acceptable material. Suppose they say, no, it is not payable, whatever it is. We don't know that you decide whether cess will be payable. If there is not payable or not, let him produce that. We'll close this. We'll close this.
Kindly fix it.
No, there is nothing. Why it is to be kept? We don't understand. See, you collect it. You collect whatever is that, entire exercise, warrant and agreed members who could be advised to seek alternative
This is the
remedy.
order of the contempt proceeding. Lordship.
Huh?
This is the order of the SLP in the contempt proceeding. Lordship. But they have challenged the order and filed in contempt proceeding. Lordship. The respondents. After that, we oppose the Supreme Court. This is the order of the Supreme Court. Lordship.
See, if any such material document produced by trader, Assam State shall not levy and collect cess in respect of special subject to explanation. Currently, it will fail to produce so and so, so and so, so and so. To provide the order dated SLP 765. Criminal appeal number.
Paragraph 10.
5491. What is 5491?
5491 is the order where they have challenged that act is virus. Lordship. Section 21 is the virus. They have challenged.
So they have failed.
And the last.
So therefore, they are entitled to cess.
It was the Supreme Court.
So in this petition, what was the direction? Why you are aggrieved? In this
What happened in this, the direction was.
17 in 17, what is wrong with this order?
Lordship, what happened in this case, this direction was, the petitioner disposed of file pending the SLP. Lordship. SLP and this contempt proceeding.
So you tell us now that SLP has been in your favor, you say.
Lordship. SLP, they have withdrawn. Lordship.
Huh?
Contempt is in the contempt proceeding. Lordship, the Honorable Apex Court says that in our considered view, the entire access of the High Court is not warranted and agreed members of respondent number 1. Respondent 1, Lordship, the present respondent would have been advised to seek the alternate remedy open to them, including redressal through the committee. In the light of the aforesaid discussion, we accordingly set aside the order passed by the High Court on 23/10/2009 in a contempt proceeding, case number 401 of 2008. Consequently, the appeal filed by appeal number 2 and 4 stands allowed. Lordship. Last paragraph. Lordship. Lordship, they want refund the case. Lordship. They pays for refund of the sales which was collected during the pendency of the in the rate proceeding.
This was outside the market area. Would say if it is outside the market area, it is admissible. Then they will pass the reason number.
See, that's the thing, no, Mr.
Which was approved by the Supreme Court.
Section 21 has been upheld, no?
Lordship.
Subject to explanation, if the petitioner are able to produce shall pass, you see whether we don't see any. Now you give full effect to the act, but if any exemption is permissible, or if it is not within the in purview of that cess, then there will be
Location outside the concerned market area, again subject to explanation of subsection. Meaning by relating to the determined exclusion outside the concerned market area, subject to expansion.
yes. So it has nothing to do with the Supreme Court now. Once it has been upheld, therefore, it doesn't change the nature of the direction. Huh? It doesn't change. It will dispose it of.
Not even interpreted 21. They are saying that it's outside market area. So since it is outside market area, it cannot levy. So if they can give admission outside market area.
Petitioner amongst involved in activity of transporting agricultural produces defined under agricultural market. In course of activity, the petitioner purchased agricultural products from several states, namely West Bengal, Bihar, and at the time of purchase of the agricultural products, the petitioner claims to be paying the market cess to the market committees of the respective place from where agricultural purchase. Thereafter, agriculture were transported to the state of Assam either by road, so and so, so and so. This is the plea. Then section 21 enables you to impose cess. No problem, you impose it. Then, and what is the plea of the petitioners?
Also, they pays for refund of the cess which was collected in the earlier.
No, that is not that. In this petition, we are challenging. There are 12. So a reading of the order would go to show the respondent Assam is permitted to collect cess in accordance with judgment. So it is permitted. Another and such collection be done uninfluenced by any such order passed in contempt proceeding.
Okay.
Maybe the respondent would be liberty to levy. So you can levy. Since it has been upheld, in this petition, once is in spite of so provided paragraph in the judgment in the are from the industry, even in respect of those specific because which according to are either sold or purchased at the destination outside the market area for which cess is levied and collected. In such circumstances, declaration sought to be that all such levy and collection of cess for the so and so be declared to be illegal for the purpose of have to produce charge indicating purpose. See, what the Supreme Court says, you can collect cess. There is no problem, you collect it. But what this present petition is saying that it has been already purchased outside, we don't, and we have paid there, whatever it is. So you and this court directed you to the petition admissible and they pass a reason order. On the other hand, if the petitioner failed to produce such document, legal fiction declared by shall prevail and they would be liable to levy it. So we don't know how you are agreeable. Let us close it. There is nothing, there is no prejudice, there is no prejudice caused to you by this. Likho, and Mr. Nane counsel for the appellant. The present appeal has been preferred against the order dated 33/2021 passed by the learned single judge in WPC number 1760 of 2012. The main issue which arose for consideration before the learned single judge appears to be that the petitioner therein are not liable to pay cess which is being levied and collected by the Assam State Agriculture Marketing Board on the ground that the specified agricultural produces were being sold or purchased at a destination outside the market area over which the cess was being levied and collected. The learned single judge, after considering the relevant provisions of law, including the judgment of this court of division bench in 5491/2001, dated disposed of on 12/9/2018, observed that and also the order of the Honorable Supreme Court passed in SLP Civil CC number 2765 of 2010 arising out of the aforesaid direction of the division bench of this court, arising out of a contempt petition filed for alleged non-compliance of the order of the division bench dated 12/9/2008 in WPC number 5491/2001, allowing the Assam State Agriculture Marketing Board to collect tax in accordance with the judgment passed by the division bench of the High Court dated 12/9/2018 uninfluenced, 2008, held that the petitioner may file necessary application before the may make claim before the Chief Executive Officer of the Assam State Agriculture Marketing Board on the claim made by the petitioner that they are not liable to pay the cess inasmuch as the specified agriculture produce were sold or purchased in a location outside the concerned market area. And thereafter, the Chief Executive Officer, thereafter the Assam State Authority, thereafter the Chief Executive Officer of the Assam State shall pass a reasoned order. It was further directed by the learned single judge that if the petitioners are able to produce any admissible and acceptable material, the Chief Executive Officer shall pass a reasoned order thereon. On the other hand, if the petitioners fail to produce any such document or material, the legal fiction declared by the division bench in para 94 of the judgment dated 12/9/2008 in WPC number 5491/2001 and other repetition shall prevail, and the concerned trader or the dealer would be liable to be levied, and all the cess collected may be admissible under the Act of 1972 and rules framed thereunder. Thus, from the reading of the said direction, it is quite apparent that this court did not interfere with the levy of cess in terms of the direction issued in WPC number 5491 of 2001 is also permitted by the Honorable Supreme Court. But observe that if the cess has been imposed beyond the jurisdiction of the market area, the concerned trader would be entitled to submit a claim for refund or otherwise before the Chief Executive Officer of Assam State Agriculture Marketing Board, and which shall decide the matter by issuing a speaking or reasoned order. Mr. Learned Counsel for the Appellant submits that there is a change in circumstances in which the SLP preferred against the contempt proceeding arising out of alleged non-compliance of the judgment order dated 12/9/2008 in WPC number 5491 of 2001 has been dismissed by the Honorable Supreme Court on huh?
2710
2710,
in the top lordship.
2610,
Lordship.
2610, 2021 in criminal appeal number 1967 of 2009. We are of the view that the said dismissal of the SLP or the criminal appeal number 1967 will have no bearing on the direction of this of the learned single judge, in as much as the learned single judge has already taken into account the observation of the Honorable Supreme Court that the Assam State Agriculture Marketing Board will be permitted to levy cess, and such power of the Marketing Board to levy cess have been upheld by the Honorable Supreme Court. Full stop. Under the circumstances, we have the view that the order passed by the learned single judge 33/2021 does not warrant any interference from us in as much as there is no direction or observation by the learned single judge which is contrary to the interest of the appellant in as much as the direction and observation direction of the learned single judge is to allow the trader to file any representation if they feel that the cess has been imposed cess has been imposed on sale or purchase which has taken place outside the concerned market area, and such representation, if made, such claim or representation made by trader shall be considered by the authority, by the Assam State Agriculture Marketing Board by issuing a reason order. Under the circumstance, we do not file any ground to interfere, to entertain this appeal, and accordingly, the appeal is closed.
Kindly record the
Huh?
kindly record that the alternate remedies open to them through the committee, not direct the CEO. The observation of the
Okay.
SLP.
Okay. Okay. उसका पहले लिखो, हाँ? However, we will have to make the observation that the Honorable Supreme Court, while disposing the criminal appeal number 1967 of 2009 and upholding the interfering with the where is it?
The last case also. Case paragraph 10, last question.
Paragraph 10.
In our considered view.
However, we have also noted observation by the Honorable Supreme Court to ensure that the the Honorable Supreme Court also made the observation that in cases where cess was levied, individual members of the respondent number 1 therein could have made their challenge before the committee, and the exercise of the High Court is not warranted, and aggrieved members of the respondent number 1 could have been well advised to seek the alternative remedy open to them, including the committee. Under the circumstances, we also and then we modify. Under circumstances, we modify the direction of the learned single judge by observing that if any of the trader or a trader is aggrieved by imposition of cess, they can seek the alternative remedy open to them, including redressal through the committee, as observed by the Honorable Supreme Court in criminal appeal number 1967 of 2009. Huh? With the above observation, the present appeal stands disposed of. It's disposed of without issuing any notice to the respondents. We deem it that it may not be necessary. We consider the nature of the case. We are of the view that the present appeal can be disposed of without issuing any notice to the respondent in the first time. Huh? Yes.
Item number 21.
Rajiv Bhattacharya. Rajiv Bhattacharya. What is it?
My lord, the petitioner's father had been declared as a foreigner way back in 1988, my lord. It is an ex parte order. If I may take your lordship to the order, my lord.
Yes.
Lord, the order is at page 35.
Yes. Absent.
Lord, order page 36.
He remained absent. So ex parte order.
Ex parte order, and my lord, this order was passed in 1988. We were
Yes.
not aware about it till the year 2019. In 2019, when the petitioner and his father applied for renewal of NRC, they came to know that the petitioner's father had already been declared as a foreigner by the ex parte order dated 14/11/1988. And that too, my lord, he has been declared to be a foreigner of the 1966 stream, not the 1971 stream, my lord. And we preferred a review before the Foreigners Tribunal Tinsukia. But the learned tribunal has dismissed the review petition on the ground that it's barred by delay. And if it would not have been for NRC updation, the OP would never come for contesting the matter. Or so, my lord, my prayer is that the matter may be remanded to the FT. And though it is a 1966 stream matter, my lord, as per Assam Accord, he is entitled to be recorded as a citizen of India. Reason being, my lord, the respondents are saying that he has been staying in Margarita town since 1970. It has been admitted by the government that he is there since 1970. If I may read the order dated 1988 order, my lord. Came to Assam without any valid authority after 1st January. And since 1970, he is living at Lajumgaon PS Margarita without any lawful authority. So it is within the stream of 1st January 1966 to 24th of March 1971, my lord.
This is your case also that you have entered during that period.
No, my lord. My case is the proceedee's father was suffering from cancer and he had expired in the year 1959 at Dibrugarh Medical Hospital, my lord.
1959.
1959, my lord.
So you are not even that stream 66 to 71, but
No, my lord.
you are a Indian.
Prior to that, I am an Indian, my lord.
Okay.
That is my case, which could not be put forward before the learned FT, my lord, because the petitioner's father was an illiterate. And on one, if I may take your lordship to the review order at page 38.
Pranab Ranjan Bhattacharya is the
Yes, my lord, the father of the petitioner. He has expired after filing of this review petition, my lord. That is why the petitioner is before your lordship, because he's not getting an NRC. He's having citizenship troubles due to the fact that his father has been declared as a foreigner. The OP had appeared before the tribunal on 21/10/1988, but the court was closed, my lord. And he was staying in Margarita town at Tinsukia, and there was no FT at that point of time in Tinsukia. The FT was in Dibrugarh at that point of time.
he had appeared on
My lord, para 2 of page 38.
5/10 to 1988, he was present. The case, above case was fixed for hearing today.
On 20.
The defendant is present. 5/10/1988.
My lord, if I may take your lordship to page 38. 38 of this petition.
Yes.
OP is represented with steps. The last line of this paragraph, my lord, OP had appeared before the tribunal on 5/10/1988, and next date 21/10/1988 was fixed for OP's appearance. OP had appeared before the tribunal on 21/10/1988, but the court was closed, and later on the OP did not turn up for his case, and that OP, being a layman, had no knowledge of appointing lawyer. My lord, due to this reason, the matter proceeded ex parte in the year 1988, and for 30 years after that, my lord, he has been casting vote. His name has been recorded in the electoral roll. His NRC was also there. When it came to updation in 2019, they got to know that he has been declared as a foreigner. And then he preferred the review petition, which has been dismissed.
Just a minute. Then what is the original
Original order is at page
36.
36.
absent state OP Bangladesh, OP born in Joleshwar of Bangladesh, came to Assam after 1st January since 1970. He is living at number 1 Lajum Gaon, Margarita, without any lawful notice was served. So and so were present. After this, he remained absent without any steps. The case under provision should be proved, but the case of allegation by remain none has come during the inquiry. So and so, thing to believe. So he was declared a foreigner
My lord.
within the purview of the present law. Now, now OP is represented. Now you in 2019 you filed this review petition
Yes, my
for the
lord. In
tribunal.
2019, we went for NRC updation, the petitioner and his father,
Mhm.
and it was rejected. Then they got to know that due to the fact that Pranab Ranjan Bhattacharjee had been declared as a foreigner in 1988, their NRC updation cannot be done. That is also annexed, my lord. We had applied for it, and page 22, my lord, is the type copy. We had applied for NRC updation, and it was page 22 is the type copy, my lord.
Page 20.
22 of the petition. This is the ARN. They had applied for NRC updation. And it was at this point of time that they came to know that Pranab Ranjan Bhattacharjee had already been declared a foreigner. That is why we procured a copy of the certified copy of the 1988 order and filed review petition. But that has been dismissed on flimsy grounds, my lord. It is an uncontested matter, my lord. As per Assam Accord, even if we assume that the state's finding is correct, then also we are entitled to be recorded as the OP's, the petitioner's father is entitled to be recorded as a citizen of India. Though that is not my case.
Yes, any judgment in your favor about this review and the
On this, my lord, with regards to substitution, I have. the
Not
order.
substitution, the delay, because they said you are delay. Had there not been no updation, you wouldn't have bothered to come. So that is a delay or what is review, ground for review after this delay. There is a delay nevertheless.
Indeed,
been
my
delay.
lord. Indeed, my lord.
So,
The review,
so still in spite of this
I am
delay,
challenging the original decision as well, my lord.
correct, correct. You're challenging that, but then you're challenging after a long time, no?
We were,
You are challenging before a tribunal too for a review. Review means
for a remand, my lord.
remand.
Remand the original matter, my lord, so that
Correct.
evidence can be laid. And
So
it can-
any judgment in your favor?
My lord, I am not well prepared with to that effect right now, my lord. Then, my lord, layman, my lord, 1988 matter. He was not aware about anything. He appeared on 2 dates. He was not informed about anything that he needs to engage a lawyer or anything. My lord will kindly appreciate one more point, my lord. 1988, the order is passed that he is a foreigner. But page 29 of my writ petition, my lord, is the electoral roll.
It is type copy, my lord.
And my lord, the petitioner's father's name is duly recorded as on the electoral roll of 1989, electoral roll of 1997 as well. Before that also, my lord, 1971, when he was in Jalpaiguri, that is also there, my lord. 1971 also. Nineteen 1989, 1997, 2019. In all the electoral rolls, the proceedee's name is there.
You wait for some time.
My lord.
Next.
Item number 22.
May it please, your lordships.
Hill Trade Agencies.
My lord.
Oh, what happened to Hill Trade? Hill Trades.
This is in this petition, my lord, the order dated 9/9/21 passed by the Learned Board of Revenue, refusing to restore the petition which was dismissed for default, my lord. That is under challenge, my lord. Now, what has happened, my lord? I don't find the taxation lawyers there because notice was issued on 21/9/22.
Yes.
Mr. B. Gogoi.
His name is shown in the court
Yes,
list.
yes. In fact, his junior was here sometime back.
Then he got tired.
I'm told he's coming.
He's coming. So let us see what he says. What is to be done today? Because
But
obviously,
in the meantime, if your lordship permit, I can
Yes.
read the facts.
yes.
Now, if your lordship kindly see page 78, that is the order by which the appeal was dismissed for non-prosecution. That order your lordship will find at page 78.
Is a VAT. Huh?
Yes,
Some
under VAT. Now, this order is dated
Section.
4/3/21. About third paragraph, second paragraph, if your lordship kindly see. First paragraph also, the learned counsel for the appellant is absent without notice. The learned standing counsel for taxation department is present.
Yes. No, what is to be done today? Any
Lordship, we have not received any instruction, and since it was only for against the restoration of the appeal before the Board of Revenue, Lordship may remand it back. Let them heard on the merit.
Okay.
Very well, my lord. Matter needs to be heard on merit, my lord.
Okay.
So then your lordship will,
So what is that? What is that impugn order then? Which is to be challenged?
the order that is under
In view of the
challenge
public stay
is at
grant.
page 87.
80, huh? Yes?
Page 78 is the order by which the appeal was dismissed for default, my lord.
Yes.
Then
yes.
we filed a review application and there the order was passed on at page 87. That is the
87.
order under challenge.
87.
87.
Learned appellant present hard learned offense restoration of dismissal order. We find no merit.
Now,
Restoration dismissal rejected.
my lord,
So if we interfere this, then what is the effect?
lord,
Then?
Under section 88 of the VAT Act, there is a power given to the learned tribunal that upon discovery of new facts, they can review the matter.
Okay.
Now, since we filed a review application giving reasons why the lawyer could not be present on 4th of March. Therefore, on that basis, we sought for restoration of the case on record, my lord. But that was rejected. So if your lordship interferes with this order, my lord, your lordship will direct the tribunal to hear the matter on merit, my lord. That is the consequence, my lord. Because the court below refused to restore the application, basically.
And you had given the reason for the absence
Yes.
of the counsel,
Yes, that
which was not considered by the tribunal.
absolutely.
Okay.
That your lordship will find at
Where
page
to find?
80.
Page 80.
Page 80 is the review
Yes.
petition because the counsel was not well, my lord.
Correct. Page, where is it mentioned?
Page 80 it starts,
Huh?
and then the reasons your lordship will find from page 82,
Yes.
paragraph 4.
Yes. Recovering for person so and so.
That the counsel for the appellant engaged in the matter was recovering from post-surgical process and was unable to move stand properly. The authorized representative cum chartered accountant so-and-so had undergone a laparoscopic surgical treatment in the month of January 21. He was on bed rest for around 1 month as he could not move properly. So accordingly, an adjournment petition seeking adjournment of hearing fixed on 7/1/21 was filed before the board. This is the previous date. The board was kind enough to consider the earlier petition and grant the adjournment of the hearing fixed on 7/1/21. Then that even after surgical process, the authorized representative cum chartered accountant of the appellant was suffering from fissure and fistula problem. He was also not attending his office regularly. He had problem of pus and blood discharge from anal area and severe pain and burn problem therein. In this connection, he was advised to take some naturopathy treatment to get rid of the problem. So accordingly, he also went to Raipur for some naturopathy treatment.
that even after coming back to Guwahati, the authorized representative of the appellant was not fit, and after a few days, he was again having problems of blood and pus discharge from the anal area. He consulted doctor, and it was advised not to take oily and spicy food and headbutt regularly and not to move or stand up unnecessarily for long duration. That further, the subordinate colleague of the council, Srimati so-and-so, who was also one of the authorized counsels in the instant case, was also on leave from 17/2/21 to 8/3/21 because of illness of her father suffering from cancer. Finally, her father was expired, and she, being only girl in the family, was busy in rituals, etc., and thus took leave. So both the counsel of the appellant were not having any information about hearing date, and as result, unable to attend the hearing fixed on 4th March 21. So this is the date on which that order was passed, my lord. What has happened on 7th January, the Priyanka, the advocate, she took time on behalf of the on behalf of the leading counsel. However, thereafter, your lordship is aware, in these courts, generally the dates are given later on, not on that day itself. So Priyanka, because of her father's illness, she couldn't go and collect the date, and therefore the leading counsel was not aware of this date, and he was also not well. This is how they both missed the date. In fact, this Priyanka's father, he expired sometime on
Yes.
17th March, no? 17th March only from cancer. February, sorry, 17th February. So these are the reasons for which they missed it, my lord.
Okay. Our Mr. K. Goswami Lanet Senior Counsel, assisted by Ms. Neo Lanet for the petitioner. Also Mr. B. Chaudhary, huh?
Yes, my lord.
For Lanet Standing Counsel?
Standing Council, Finance and Tax.
Finance, Finance,
Finance and Taxation.
Finance Taxation. The present petition has been preferred, being agreed by the order dated 9/9/2021, passed by the Assam Board of Revenue in case number 4STA within bracket RFT 2021, by which the application filed for review of the earlier dismissal order dated 4/3/2021, passed in case number 829 STF 2017 by the petitioner, was rejected. It has been submitted that it has been submitted by Lanet Senior Counsel for the petitioner that the dismissal of the appeal preferred by the present petitioner under section 80, read with section 4 of the Assam Value Added Tax 2003, filed by the petitioner, present petitioner, was disposed of. Was dismissed on account of failure, on account of the absence of the learned counsel for the appellant. Full stop. It has been submitted that the inability of the counsel for the appellant on 4/3/2021 was occasioned due to the personal illness of the counsel, who was suffering from who had undergone operation, surgical operation, were undergone for surgical operation. What is that surgical operation?
Well, he was suffering from chronic posterior fissure and fistula.
As he was suffering from chronic fissure and fistula.
Yes.
And for which he was taking treatment. And as such, the petitioner, the counsel could not appear on a date fixed. Unfortunately, the junior counsel assisting also remain absent on the days fixed by the board on account of the illness of her father, who was suffering from cancer and who unfortunately expired, and accordingly she had to also attend to attend to the rituals and other requirements Under the aforesaid circumstances, the counsel for the appellant remained unrepresented on 4/3/2021. The aforesaid facts were brought to the notice of the board by filing an application on. When did you file the application?
Well, this is on 22/3/21, page 80.
22/3/21.
22/3/21.
22/3/21.
Yes.
And brought to notice to the board and seeking recalling of the aforesaid rejection order, dismissal order. Unfortunately, the board, via impugn order dated 9/9/2021, rejected the said plea on the ground that it is devoid of merit. Full stop. In the result, consequently, the appeal of the present petitioner has been disposed of not on merit but on default. According to learned senior counsel for the petitioner, there are sufficient grounds sufficient ground to explain the absence of the appellant. Counsel for the appellant on 4/3/2021, when the board rejected the appeal, is as mentioned above, and also brought to the notice of the board. Under circumstances, it has been submitted that the impugn dismissal order dated 9/9 dismissal impugn order dated 9/9/2021 passed by the board may be interfered with and allow the petitioner to appear to contest to re-agitate the appeal and which may be considered by the board on merit. We have having heard Mr. Chaudhary, Mr. Chaudhary, learned standing counsel, having considered the submission advance, in all fairness, has not raised serious objection. Considering the suggestion as the said absence of the counsel was due to reasons which are beyond his control. We also are satisfied with the explanation proffered by the petitioner in the present case of the reasons for the absence of the counsel before the board when the appeal was taken up. Accordingly, we also view that the appeal preferred by the petitioner may be considered on merit, not by of default, as has been done. Under the circumstances, we are satisfied with the present petition. The impugn order dated 9/9/2021 passed by the Assam Board of Revenue in case number 4 ASTA within bracket RST/2021 is set aside, and set aside. We also so we have challenges 4/3/21 also, perhaps. We are, for the reason discussed above, we also view that the order dated 4/3/2021 passed by the Assam Board of Revenue in case number 4 and so will require to be recalled so as to enable the present petitioner to argue the matter appeal preferred under section 80 read with section 4 of the Assam Value Added Tax Act 2003 on merit. Full stop.
Just one thing, my lord, where your lordship have said about the cases, there are two cases, STA 8 of 2017 and 9 of 2017. Somewhere your lordship, I think, has mentioned only one.
No, we have referred to 4 STA RST. That is your application. That is that. But here it is 8 to 9. 8 to 9. Accordingly, the present petition is allowed by setting aside the impugn order dated 9/9/21 passed in so page 87, as well as the impugn order dated 4/3/2021 passed in 8 to 9 STA 2007 and so. And the petitioner will appear before the board on or before within. You appear, let him appear within a period of 2 weeks from today. Whereupon the board will take up the matter, the appeal, and consider same on merit.
Deeply obliged.
Rajendra Sharma.
For orders, item 23.
My lord,
Rajendra Sharma,
this is an appeal before your lordship against the import order-
2016.
Yes, my lord, passed by the learned single judge in writ petition number 752.
Page number. What is the impugn order? This order dated 10/12/2015.
15, my lord.
You have preferred appeal against this order. What
Yes.
is the direction of the learned single judge?
Lordship may appeal the informed judgment.
I hold that direct recruit class 2 engineering is not applicable to the present case.
Yes.
Dismissed.
69, paragraph 8,
Page
69. Paragraph 8.
is about regularization.
Not regularization, it was a consideration of seniority.
Seniority. Yes, who is for the other side?
Yes, Malak.
You are for the petitioner.
No, Malak, I'm for the government, Malak.
You are
Education.
for the government.
Education
Oh,
department.
Rajendra Sharma. You are agreed.
I
You
am
want the
applicant.
seniority.
Yeah.
That was rejected.
Yeah.
You are seniority.
Relying Supreme Court judgment.
You want to count the ad hoc service or something like that?
Yes, yes,
Yes,
Malak.
yes. Since 10/8/1989, initiative.
Before regularization, Malak.
Before regulation.
Yes.
Direct recruit class 2, see, there are so many conditions to be fulfilled. The vacancy must be substantive and then you must have. That has been explained by Aghornath Day also perhaps, that substantive, then the due process must have been followed.
Yes, Malak.
If you don't, you just say backdoor entry, sorry, like that. I don't know, what you have backdoor entry or front door entry?
Front door end.
Front door entry. That period, so you are claiming seniority for that period. Let us see that service you rendered during that period. What is the nature of the service? Nature of the service?
I was a subject teacher in the subject of.
Then it shows that appointment, initial appointment on ad hoc basis.
Lordship will find. It has been discussed in this input order in detail, my lord.
Okay, okay,
Lordship
very
will
well.
find,
Okay, then.
From the 65, matter 68.
68.
Paragraph
Petitioner's
2.
counsel submit the petitioner initially appointed subject, teacher in business, so and so, Rongia, white order issued. The appointment receipt was made on a proposal of public general meeting. Public general meeting?
By the school managing committee.
Huh?
It was by the school managing committee, Malak.
Oh. Acha, public general meeting. So public all appoint. I didn't know. I thought public only elects
No,
Gram Panchayat, Jila Parishad. Public also appoint teachers.
no, it was school managing.
Okay, public general meeting held on so and so, and instruction given in meeting. The police council, the police join. We want to see that order.
My lord.
We want to see that initial appointment order. Have you annexed a copy of the order?
Yes, in writ petition, lordship.
Yes. Page number. That will indicate the nature of your entry, birth. Caesarean or natural birth. Huh? It will show what kind of, how you came, how you took birth as a employee, government employee. Yes, let's space. Appointment, initial appointment order. Let us see. Is it the method of appointment? No. Then?
With regard to appointment, there is no dispute. my lord.
No. There is no
Lordship,
dispute about appointment. The manner of appointment, is it the normal, regular mode of appointment?
It was subsequently regularized
Oh, that's a thing, no? It may be subsequently regularized.
in the year 2003.
But then that does not, will not grant you that benefit, seniority. You may get this salary and all those things, but seniority, because seniority will be, see, it will go along with your regular appointment.
But there are some, it's a conflict of various laws laid down by the Honorable Supreme Court as well as the Honorable High Court.
What
in
does the
such type of
Honorable
matters.
High Court say, or whatever Honorable Supreme Court say
Says,
about your ad hoc period?
Yes, I will rely this judgment, but Lordship will first of all find out the
So are you, so today is when do you want to argue? Tell us. with all judgments.
Any day in the first, second week of December.
Okay. 5 page space.
30 days. Double.
Page 32, see, with reference to subject, I have joined subject teacher. Write your letter dated 5/8/89. Where is that 5/8/89? Show us. If you can't show that, then sorry, we can't hear you, because that is the basis of your appointment. That appointment, if you want seniority, the appointment must be regular, not kind of ad hoc or
Not
temporary. Huh? 5/8/89. Where is that letter?
89, I am not finding here in.
If you don't find, then what can we do? It is your case.
5/8.
The petitioner comes submit the director also issued wherein the 3 different categories created, so and so, so and so, so and so. He further submit the order when allotted post of so and so. Submit is subsequently 2003, so and so wrote a letter to so follows. In inviting a reference, I am directed to state that the upgraded school and the subject teacher were appointed by the managing committee of the school after due approval, so and so their appointment have been treated as regularly made. Is SS no more regulation or is required? Petitioner confirms that this letter is to affect the period prior to service allotment of post subject teachers has been to be counted for seniority. The petitioner confirms that as a petitioner joint school so and so should be. Regards rely on apex or show us that what is that direct recruitment class 2, this one 1990, which paragraph you are relying? If the initial appointment, B, if the initial appointment is not made by foreign procedure, so you have to tell us.
That was the matter of challenge.
So show us in that direct recruitment case, which paragraph will help you? Have you brought the direct recruitment case?
Yes.
Which paragraph?
Entire case rests on that. Judgment.
No, don't show the entire case, only the relevant paragraph on which you are claiming seniority. Direct recruitment. Nahi. Dongle nahi.
Yes,
naki?
I have a copy.
You have a copy, we don't have a copy.
I am providing you.
You're providing? Very good. Huh? Citation, but you tell that. Which paragraph you are relying on?
Though I am not fully.
I find that a school had appointed teacher in 1989. The said post was provincialized only with effect from 86. Para 8, Mr.
Yes.
And a petitioner appointed said post in 1996.
At 745 of the judgment. B.
Okay.
My case is on the paragraph B.
Paragraph B.
B9.
You have given how many copies?
I have also another copy, my lord. I can provide.
I have to give because we can't share.
Yes, yes.
We can't share it. Online now. Yes, para number, you show us. Para number, which are line? Para number?
B.
Not para number, B. Page number?
Is 745.
745.
745.
Your 745. Your judgment does not have 745.
Yeah, Lordship.
744. B. If the initial appointment is not made by following the procedure laid down by rule, but the appointee continues in the post uninterruptedly till the regularization of his service in accordance with the rules, the period will be counted. Now, this has been explained in West Bengal, Agordenath. Bring Agordenath.
Another judgment of the apex court, my lord, in L. Chandra Kishore Singh versus State of Manipur. Also similar.
Agordenath. Mr.
In para 14 and 15.
Mr. Khatunia.
Yes, my lord.
Should we allow the appeal? Should we allow the appeal?
No, my lord.
No. On what ground we should not allow?
Because
Why?
his initial appointment was made by the
Oh, judgment.
school.
Judgment. We have read the facts. Judgment.
For that, my
Is
lord,
B. He says direct recruitment B. B is applicable?
no, my lord.
No. Why?
Because, my lord, initially his post was sanctioned later on, my lord. Initially, he was appointed by the
See, that's
school.
what B also says, if the initial appointment is not made by following the procedure laid down by rules,
But
but the appointee continues in the post
in that case,
uninterruptedly.
here, there is no post, there is no sanction post,
Oh, that's what I'm saying.
because here
Overnight
the
day.
initial appointment is not proceed with due procedure, but in this instant case, there was no
Overnight
post.
day. Overnight day. You don't have overnight day judgment. Citation. I
Today,
have forgotten overnight day. You don't have overnight day.
today, may fix it on tomorrow, I will place,
Tomorrow.
Tomorrow. Okay, tomorrow. Yes, next.
Time being 21.
Yes, 21.
Well, initially the petitioner was, the father of the petitioner was declared foreigner in 1988. Then they preferred a review in 2019, my lord. Thereafter review was rejected on the ground that the review was not preferred within, my lord, the stipulated period. Now, my lord, though the review was rejected in 2009, they are approaching before this 2019, my lord, they are approaching before this honorable court in the 2022. Even there is no explanation, my lord, I'm not saying, at least there must be, should have been some explanation to the defect.
So you are a double
My lord,
double
that
zero
part-
party. Number one, you file a late review. Again, you have come again late against the dismissal of the.
The review one, I have a response, my lord. 30th December 2019, the review petition was dismissed, my lord. 30th December. There are only 2 months passed in between when the petitioner's father was sick. And then March onwards, COVID started.
Have you stated in your petition?
My lord, delay part I have explained now.
Okay.
And thereafter, the COVID period came and I have approached, and then the petitioner's father expired on 14/5/2021. Death certificate is annexed to 1, my lord. He expired on 14/5/2021 at Munaf Memorial Hospital. Now, my lord, immediately after that, we have approached this honorable court. The case has been filed in the month of May, my lord. Because, my lord, the petitioner himself also, he does not reside in, he's not at present residing in Tinsukia. He is presently working in Delhi, my lord. So he could not get leave. So in between, there was a slight delay in filing as well, after the matter was received by me. And that part has been exchanged now. And if my lord, and one more document, my lord. One more document, my lord, if I may draw your lordship's attention.
Tomorrow or day after tomorrow, tell us. Get some judgments.
There is no explanation in the situation, my lord.
Well, we'll see that. Day after tomorrow, when? Come
Tomorrow.
tomorrow,
Oh, sorry, my lord. Yeah,
day after.
my lord.
Tell us any date,
My lord, if it could be on Monday, my lord.
Monday, very well. So we'll bring some judgment.
My lord, I'll try my best.
If you can bring judgment, very well. If we bring judgment, we'll impose course on you.
But I'll try my best. my lord.
If you can bring judgment, then our course will be cancelled
But when
because we
sufficient,
have a judgment.
sufficient cause is there, my lord.
So if
Sufficient
you
cause for
can't
the
bring a
delay is
judgment, then we'll impose cost on you If you can bring a judgment, that will cancel our judgment. You don't have to pay anything because we have a judgment with us. But I don't know that whether this judgment helps Mr. Payang also, that you have to see. You have to bring some judgments. I'll list this matter again. Monday.
Monday, my lord, 28.
Okay, Monday.
Deeply obliged.
For orders, item 24.
May please your lordships, this IA has been filed praying for some modification of the order passed by this honorable court. Lordship,
Yes, item number?
item number 24, lordship.
Item number 24, Noor
Yes,
Jahan.
Noor Jahan,
Why it is listed?
IA has been
For what?
filed, lordship.
I for what?
IA for slight modification of the order dated 31.
What modification? Why modification?
Lordship, kindly peruse the.
No, what modification?
Modification
About what?
as regards non-mentioning of the word bail or not to detain in the order, lordship. That has been creating some hardship to the petitioner, so she could not
You
appear.
have,
There's a similar order, lordship, I have annexed.
you have passed an order, no?
Yes, lordship, I have annexed the order.
Yes, Mr. That
My
And
lord,
some
this is
time
my-
maybe also.
my lord, my humble prayer will be, this is not a correction of some order, my lord. This is modification of the order by way of the my lord interim.
So we'll treat it as a
So, my lord,
modification, the
it may be-
application for modification.
Yes, modif.
Yes, next.
Item number 25.
Tapir Tamut. Oh, there's some Arunachal matter, yes. Who is for the petitioner?
Now this matter has already become infractuous.
Infractuous, okay.
Yes, my lord,
How
government.
do you say
Yes,
this?
my lord, government has already, my lord, amended the, my lord.
Oh, I see. So what was the relief claim in that petition? Let us
The
see.
relief claim in the petition is that, my lord,
Application for national for direction to make frame rules appropriate
yes,
time
my lord,
prescribed
rule has been
procedure,
framed.
execution enforcement decision of village authority.
Yes, my lord. Your lordship kindly come to the, my lord. 4, my lord. Amendment of clauses 11, 14, and 19 shall read over for subsection 2, section 40 Assam Panchayat regulation. Execution and enforcement of the order of decree passed by the village authority. If the person against whom a decree order has been passed by the village authority fail to pay or comply with such order or decree within a period of 30 days, the party in whose favor such decree order has been passed may apply to the concerned deputy commissioner or assistant commissioner as the case may be for
Okay, okay. Though no one is present for the petitioner, in view of the submission made by the learned additional advocate general of the state of Arunachal Pradesh, Mr. N.N.B. Chaudhary, assisted by Mr. Chandran, we have the view that the present petition can be closed as infructuous. Next para. In this petition, the petitioner has sought for a direction to be issued to the respondents to frame necessary appropriate rules prescribing the procedure, mode and manner of execution and enforcement of decree or judgment or decision passed by the village authority under the Assam Frontier within bracket Administration of Justice bracket close regulation, 1945. It has been submitted by Mr. Chaudhary Lana, Additional Advocate General, that during the pendency of this petition, the state authorities have issued a gazette notification on 14th of November 2022, whereby certain amendments were brought in the Arunachal Pradesh Civil Courts Act 2021, within bracket Act number 4 of 2021, in which it has been also in which the amendment to clauses 11 and Roman 11 and clauses Roman 14 of subsection 1 of section 27 of the aforesaid act has been brought in, by which the manner by which the modality of executing and enforcing an order or decree passed by the village authority has been specified. As per the aforesaid amendment, reads as follows. Under the circumstances, we have the view that the relief sought for in this petition has been substantially substantially addressed, and accordingly, according to the present petition is closed. As submitted by learned senior, learned additional member of the state. Yes. That's all. Hearing, then we will hear the criminal matter perhaps. 1 to 4, not now, maybe at 2 p.m. We'll hear you. At 2 p.m. we'll hear the hearing.
Single bench.
Single bench. Single bench will only be after the. See, single bench will be only after the DB we rise, no? Because I think single bench some matters arbitration. Then we'll consider after the DB, or you want to some other date. Whatever. What we are.
Yes.
You have concluded.
I have concluded just 2 judgment I will place.
Okay, very well. Let us finish with this judgment hearing. Yes, Judge, you want to say something about single bench? Because the division bench will take some time. Your hearing, how long will take?
15 minutes.
15 minutes.
On my part.
Very good. 15 minutes. Jet Kamar also 15 minutes, 20 minutes. Okay, then you have to wait for half an hour or so. Then after that, we'll take up this single bench matter.